I have more respect for a man who lets me know where he stands, even if he's wrong.
We always said in Black Panther Party that they can do anything they want to us. We might not be back. I might be in jail. I might be anywhere. But when I leave, you can remember I said with the last words on my lips that I am a revolutionary.
New Nubian.
Civil Procedure, Lawsuits, Jurisdiction and Rules of Court, presented by Dr. Jonah Sanders. Course objectives: to provide a practical and conceptual understanding of civil procedure, how lawsuits are initiated, the role of courts, and the procedural rules that govern the litigation process in civil cases. Course Outline Module 1, Introduction to Civil Procedure Module 2, Jurisdiction and Venue Module 3, Filing a Lawsuit Module 4, Pretrial Procedure Module 5, Trial and Judgment Module 6, Review and Case Scenarios. Course Syllabus Module Topics covered Time Learning Objectives 1, Intro to Civil Procedure Overview, Goals, Timeline 15 minutes, Understand Purpose and Structure of Civil Procedure 2, Jurisdiction and Venue Power of Courts, Proper Locations 25 minutes explain when and where cases can be filed 3, Filing a Lawsuit Complaint Service responses 20 minutes, Learn how civil cases begin and are defended 4, Pretrial Procedure Discovery, Motions, Conferences 25 minutes, Understand the Tools and Rules before Trial 5, Trial and Judgment Evidence Verdict, Appeals 20 minutes, Follow how a trial unfolds and is resolved 6, Review and Quiz Hypotheticals plus Assessment 15 minutes, Apply Concepts and Test Knowledge Retention. Module 1, Introduction to Civil Procedure. What is civil procedure? Definition: civil procedure is the body of law that sets out the rules standards courts follow when adjudicating civil lawsuits. Key focus: structure, processes and rules, not the substantive law. Applies to lawsuits between individuals, organizations, or the government. Civil law versus criminal law. Civil law: criminal law parties. Plaintiff as defendant government versus defendant purpose resolve disputes and provide remedies, punish wrongdoing and protect society. Burden of proof, preponderance of evidence, beyond a reasonable doubt, outcomes, damages, injunctions, fines, imprisonment. Why civil procedure matters: ensures fairness, equal treatment under the law, promotes efficiency, avoids unnecessary delays and costs, provides predictability, establishes expectations and guides legal strategy, protects rights, offers procedural safeguards to all parties. Ensures fairness. Definition: everyone, regardless of status, gets equal treatment under procedural rules. Key points: right to be heard, neutral decision maker, access to information. Example: compare a wealthy corporation and an individual plaintiff, both following the same procedural rules. Engagement prompt: can you think of a situation where fairness in procedure made a big difference in the outcome of a case? Promotes efficiency. Definition: civil procedure streamlines the legal process to avoid waste. Key points: deadlines for filings and motions, case management by judges, encouragement of settlement or mediation. Example: a multi-year litigation that ended quickly due to a motion to dismiss based on procedural grounds. Engagement prompt: why do you think delays in court cases can be harmful to justice? Provides predictability. Definition: clear rules help parties plan and manage litigation. Key points: legal teams can form strategies based on deadlines, discovery, and procedures, reduces surprise and gamesmanship, Example, knowing when a motion must be filed can determine the entire case strategy. Engagement prompt. If you're defending a client, how might predictable rules help you prepare? Protects rights definition. Civil procedure ensures constitutional and legal rights are respected. Key points. Right to notice and hearing appeal processes, due process safeguards. Example, a defendant being served improperly and winning a dismissal based on procedural violation. Engagement prompt. Have you seen a case where someone's rights were protected by following procedure? Goals of civil procedure: fairness, neutral process for all parties, efficiency, timely resolution of disputes, predictability, clear rules guide litigants and courts. Fairness, a neutral process definition. Everyone, regardless of power or resources, has the same procedural protections. Key components. Impartial judges and juries, equal opportunity to present evidence, transparency. Example, a large corporation and a small business must both follow the same discovery rules and trial process. Discussion prompt. Can fairness exist if one party has more resources but both follow the same rules? Why or why not? Efficiency, timely resolution definition. Avoiding unnecessary delays or burdens in the justice process. Key components. Streamlined case management by judges' use of summary judgment and motion practice to resolve issues early, encouraging settlement. Or ADR. Example, a judge uses a pre-trial conference to narrow the issues, reducing trial time from 6 days to 2. Discussion prompt. What are the risks if a case drags on too long? Who is harmed most by delay? Predictability. Clear rules for all definition. Established rules ensure all parties know what to expect. Key components. Filing deadlines, notice requirements, defined stages. Example, a plaintiff can prepare for trial knowing when the defense must respond and how discovery will proceed. Discussion prompt. How do predictable rules help lawyers and clients feel more secure about their rights? Civil litigation timeline, overview, pleading stage, complaint and answer discovery stage, exchange of information, pre-trial motions, legal issues resolved before trial, presentation of evidence and arguments, post-trial motions and appeals, possible further review, judgment enforcement, collecting what was awarded. Pleading stage, complaint and answer, what happens. Plaintiff files a complaint outlining the legal claim. Defendant responds with an answer. Purpose, frame the issues of the case. Example, a consumer sues a business for breach of contract. The business denies it and may file a counterclaim. Prompt, why do you think it's important for the defendant to respond formally and on time? Discovery stage, exchange of information. What happens? Both sides exchange documents, take depositions, and issue interrogatories. Purpose, prevent surprise at trial, promote settlement. Example, emails, contracts, and expert witness reports are shared. Prompt, how might discovery influence whether a case settles before trial? Pre-trial motions, resolving issues early, what happens? Motions to dismiss, motions for summary judgment, etc. Purpose, narrow the issues or potentially resolve the case without trial. Example, a judge rules certain evidence can't be used or dismisses one of the claims entirely. Why might a party want to avoid going to trial if possible? Trial, presentation of evidence and arguments. What happens? Witnesses testify, documents are presented, and attorneys argue the case. Could be jury trial or bench trial. Purpose, decide disputed facts and apply the law. Example, a jury determines whether a doctor was negligent in a malpractice case. What role do you think juries play in achieving justice in civil trials? Post-trial motions and appeals. The losing party may file a motion for a new trial or appeal. Purpose: review possible errors in how the trial was handled. Example: an appeal argues that the judge improperly excluded key evidence. Should every losing party have a right to appeal? Why or why not? Judgment enforcement winning party uses legal tools to collect the money or property awarded. Purpose: ensure the judgment has real effect. Example: a landlord wins a case for unpaid rent and garnishes the tenant's bank account. What if someone wins in court but never receives the money? Is justice served? Key takeaway: civil procedure governs how lawsuits unfold. It differs significantly from criminal procedure. Its goals include fairness, efficiency, and predictability. Understanding the litigation timeline helps demystify the court process. Civil procedure governs how lawsuits unfold. Explanation: civil procedure is the roadmap of a lawsuit. It dictates how a case progresses from start to finish, not what the case is about. Examples: filing deadlines, discovery, motions, trial format, all guided by rules of procedure. Prompt for group or individual reflection. Why do you think it's important that we have standardized rules for all cases? Goals of civil procedure: fairness, efficiency, predictability. Quick recap: fairness, equal treatment, impartial process. Efficiency, timely resolution, cost saving. Predictability, clear rules guide legal strategy. Which of these goals do you think courts struggle with the most, and why? Understanding the litigation timeline helps demystify the process. Timeline flash review. Pleadings, discovery, pre-trial motions, trial, post-trial enforcement. Why it matters. Knowing the steps gives parties realistic expectations and reduces fear of the unknown. How might understanding this timeline change how a person approaches a lawsuit? Questions and discussion. What questions do you have about the civil litigation process? How does civil procedure affect access to justice? Why is the burden of proof lower in civil cases? In what ways might civil procedure be misused or abused? How can understanding civil procedure help you outside of law school? Module 2: Jurisdiction and Venue. What is jurisdiction? Legal authority of a court to hear a case. Without jurisdiction, rulings are invalid. Two main types: subject matter jurisdiction, personal jurisdiction. Definition: jurisdiction equal legal authority. Core idea: jurisdiction means a court's power to hear and decide a case. Why it matters. Without jurisdiction, any decision the court makes is void, like a referee trying to officiate a game outside their league. Example: a Florida court can't hear a case that only involves California residents and events. Prompt: what do you think would happen if a court ruled on a case without having the proper jurisdiction? Subject matter jurisdiction: the court's power to hear the type of case. Types: state courts handle most civil cases. Federal courts only specific cases. Example: a bankruptcy court can't hear a personal injury case. Key rule: the nature of the case must fit the court's legal category. Why do you think some cases must go to federal court while others stay in state court? Personal jurisdiction definition. The court's power over the people or parties involved in the case. When it applies, defendant lives or does business in the state defendant committed an act in the state defendant consents to jurisdiction. Example. You can't sue a New York company in Texas unless the company has ties to Texas. Visual aid idea. Map showing a person in state A suing someone from state B when it's allowed. Prompt. Should someone be sued in a state they've never even visited? Why or why not? Subject matter jurisdiction definition. Court's power over the type of case. Example. Bankruptcy court can't hear a criminal case, federal versus state courts. Definition and importance definition. Subject matter jurisdiction is a court's legal authority to hear a particular type of case. Why it matters. If a case is filed in the wrong court, it can be dismissed, wasting time and resources. Prompt. Why do you think courts are limited to certain types of cases? Real-world example scenario. A person tries to file a criminal assault case in bankruptcy court. It gets rejected. Clarification. Bankruptcy court handles debt and insolvency issues. Criminal court equals prosecutes crimes and sentences offenders. Lesson. Even if both are courts, they are not interchangeable. Can you think of another mismatch, like trying to bring a divorce case to traffic court? Federal versus state courts. A. State courts. Broad authority typical cases. Family law, contracts, torts, property, probate. Why? State courts handle most daily legal disputes. Example. A car accident between two locals is a state court case. Prompt. Why do you think state courts handle the majority of legal matters? B. Federal courts. Limited authority only handle. Federal questions diversity jurisdiction. Example. A civil rights lawsuit or a lawsuit between a California resident and a Texas corporation over $100,000. Why do you think the dollar amount matters in federal diversity cases? Examples of subject matter jurisdiction. Federal, immigration, bankruptcy, federal crime state, divorce, contracts, traffic violations. Why examples matter. Subject matter jurisdiction can feel abstract. Real-world examples make it concrete. Understanding which court handles what helps avoid misfiling a case. Prompt. If you were suing someone for a car accident, where would you go, state or federal court? Federal court jurisdiction. Examples. A. Immigration cases. Only federal courts can decide on visas, deportation appeals, or asylum. Example. A person denied asylum appeals in federal court. B. Bankruptcy. All bankruptcy cases must go through federal bankruptcy courts. Example. A business filing Chapter 11. C. Federal crimes involving federal laws. Example. FBI charges a person with wire fraud. Prompt. Why do you think immigration and bankruptcy are handled only by federal courts? State court jurisdiction. Examples. A. Divorce and family law handled exclusively by state courts. Example. Child custody, spousal support, adoption. B. Contracts and property disputes, local business deals, landlord-tenant conflicts, etc. Example. A customer sues a contractor for unfinished work. C. Traffic violations, speeding tickets, DUIs, parking disputes. Example. A driver appeals a license suspension in state court. Why is it better for everyday disputes like traffic tickets or divorce to be handled locally? Interactive scenario quiz. Which court would hear the following cases? A man sues over unpaid child support. State court. A woman files for bankruptcy. Federal court. A company is sued for breach of a $1 million contract between companies in different states. Federal court. Someone gets a speeding ticket. State court. Personal jurisdiction power over the individuals in the case based on residency, presence, consent, or minimum contacts. What is personal jurisdiction? Definition: a court's authority over the people involved in a lawsuit. Why it matters. Even if the court has subject matter jurisdiction, it still needs personal jurisdiction to issue valid rulings. Analogy: think of it as the court's reach. It must have a legitimate connection to the person being sued. Prompt: can a court in California force someone in Florida to come to trial? It depends on jurisdiction. How is personal jurisdiction established? A. Residency. If the defendant lives in the state, that state's courts can usually hear the case. Example: a person who lives in Georgia can be sued in Georgia. Why do you think courts always have power over their own residents? B. Physical presence. If the defendant is physically present in the state when served with legal papers, jurisdiction attaches. Example: someone visiting a state and gets served while there. Note: doesn't apply if presence is coerced or tricked. C. Consent. If the defendant agrees to the court's authority. Example: signing a contract with a clause saying disputes will be settled in Texas courts. Prompt: have you ever agreed to a terms of service clause without reading it? It might include jurisdiction terms. D. Minimum contacts. A person or company has sufficient connections with the state. Example: a business regularly sells products to residents in another state or advertises there. Landmark case mention: International Shoe Co. versus Washington established this standard. Should a company be sued in a state just because it ships products there? Visual diagram. Create a map-style graphic showing a plaintiff in state A, a defendant in state B, a line between them showing OK to sue if defendant lives in B, defendant does business in A, defendant agreed to be sued in A. Types of personal jurisdiction in personam: over the person in rem, over property quasi in rem, property rights between parties. Introduction. What we're covering: the three types of personal jurisdiction. In personam, over the person in rem over property, quasi in rem over property between specific parties. Why it matters. The type of jurisdiction determines what kind of judgment the court can issue. In personam jurisdiction, power over a person definition. The court has authority to make decisions affecting the person directly. Applies when residency, presence, consent, or minimum contacts are established. Result: court can order a person to pay money, do something, or stop doing something. Example: a Georgia resident sues a Florida business for breach of contract. Why is this the most common form of personal jurisdiction? In rem jurisdiction, power over property definition. The court decides rights related to property located within its territory, regardless of the owner's location. Judgment affects the world's legal interest in the property. Example: a court quiets title to land located in Texas, even if the owner lives in New York. Prompt: why should a court in Texas have power over land in Texas, even if the owner lives elsewhere? Quasi in rem jurisdiction. Property used to settle personal dispute definition. The court uses a person's property in the state to resolve a dispute between specific parties, not about the property itself. Judgment affects only the parties involved in the case. A plaintiff sues someone from another state and attaches their vacation home to satisfy a debt. even if the case isn't about that home, requires minimum contacts post Schaffer v. Heitner. Do you think it's fair to seize property to resolve a dispute that has nothing to do with the property itself? Establishing personal jurisdiction service of process within the state consent to jurisdiction, long-arm statutes minimum contacts doctrine. Introduction. Why establishment matters. A court cannot proceed with a civil case until it has proper personal jurisdiction. Jurisdiction must be legally established, or the case can be dismissed. Service of process within the state definition. If the defendant is physically served with legal documents while in the state, the court gains jurisdiction. Example, someone visiting New York is served with a lawsuit while shopping. New York courts have jurisdiction. Key point, even brief presence can trigger jurisdiction if properly served. Limitations. Can't trick someone into entering the state just to serve them. Is it fair to be sued in a state just because you were visiting temporarily? Consent to jurisdiction definition. A person or business voluntarily agrees to be sued in a particular court. Forms of consent express. In a signed contract implied, by failing to challenge jurisdiction early in the case. Example, clicking I agree to a website's terms may include a clause agreeing to be sued in another state. Have you ever agreed to jurisdiction by clicking a button without realizing it? Long-arm statutes definition. State laws that allow courts to reach defendants outside the state, if they have sufficient ties, covers activities like doing business in the state causing injury in the state owning property in the state. Example, a Florida business that sells products to California, customers may be subject to California's long-arm statute. Prompt, why do you think states created long-arm statutes? Minimum contacts doctrine definition. From International Shoe Co. versus Washington, a defendant must have sufficient contacts with the state so that exercising jurisdiction is fair and reasonable. Factors considered. Purposeful activities in the state, foreseeability of being sued. Their example, an online seller consistently shipping to Texas customers may be subject to Texas courts. What's a fair number of contacts to require before someone can be sued in a state? Jurisdictional limits. Jurisdiction is limited by geography and law sovereignty and due process concerns. Introduction. Why limits exist. Jurisdiction isn't unlimited. Courts must respect boundaries set by law, geography, and constitutional rights. If these limits are exceeded, the court's ruling can be void or challenged on appeal. Geography sets boundaries. Key point. Courts generally have jurisdiction only within their own territory. Example, a California court can't hear a local dispute in Georgia unless there's a strong connection. Exceptions, long-arm statutes. Prompt, why would it be unfair for a state court to claim jurisdiction over someone with no ties to that state? Legal limits. Subject matter restrictions. Each court's power is defined by law. Bankruptcy courts can't hear criminal cases. Family courts can't decide corporate contract disputes. Legal framework. Jurisdiction is shaped by constitutions, statutes, and court rules. How might it harm justice if courts could hear any kind of case they wanted? Sovereignty and state power definition. States are sovereign entities under the US Constitution and can't intrude into other states' affairs without justification. Impact. Limits how far one state's courts can reach into another state's citizens or laws. Example, a state can't enforce its laws in another unless there's a recognized legal connection. Prompt, how does respecting state sovereignty help maintain balance in the legal system? Due process and fairness. Constitutional protection. The 14th Amendment guarantees no one will be deprived of liberty or property without due process of law. In civil cases, A person must have notice and a fair chance to be heard and not be dragged into court arbitrarily. Example: a business with no contacts in a state shouldn't be sued there just because the plaintiff lives there. What would happen if courts ignored due process when asserting jurisdiction? What is venue? Venue, the proper geographic location for trial, refers to the most appropriate location, not authority. Definition and key concept: venue equal location. It refers to the most appropriate geographic location within a court system for the trial to take place. Important distinction: venue is about convenience, not legal authority. Analogy: jurisdiction decides if a court can hear the case. Venue decides where the case should be heard. Prompt: why do you think the law cares about where a case is tried? How venue is determined. Common venue considerations include where the defendant lives or does business, where the events occurred, where the property in dispute is located. Example: a car accident in Chicago involving Illinois residents should be tried in Cook County, not another part of the state. Federal cases, often based on judicial districts. Prompt: which venue seems more appropriate, where the defendant lives or where the event happened? Changing venue: courts may transfer venue for inconvenience, pretrial publicity, fairness to parties or witnesses. Example: a high-profile case is moved to another county to ensure a fair jury. Prompt: what are good reasons someone might ask to move a trial? Jurisdiction, venue, legal authority, geographical appropriateness. Can't be waived, can often be waived or changed. Required for validity. For convenience, make it image, black background, white letter. Determining proper venue: where the defendant resides, where the event occurred, where property is located. Introduction: why venue matters. Venue ensures the case is heard in a logical, fair, and convenient location. Not about authority, it's about geographic appropriateness. Where the defendant resides rule: venue is proper where the defendant lives. It's fair to require someone to defend a case where they live or operate. Example: if you sue someone who lives in Atlanta, Georgia, you generally file in an Atlanta court. Prompt: should people always be sued where they live? What if they did something wrong in another state? Where the event or omission occurred rule: venue is proper where the events happened that gave rise to the lawsuit. Examples: a car crash in Orlando, venue is in Orlando. A contract was breached in New York, venue is in New York. Why it matters: witnesses, evidence, and impact are usually found where the event took place. What happens if the defendant lives in one state but the injury occurred in another? Where property is located rule: in rem cases, venue is proper where the property is located. Examples: disputes over land titles must be filed in the county where the land sits. Foreclosure of a vacation home in Colorado, venue is in Colorado. Prompt: why do you think courts require in rem cases to be filed where the property is? Determining proper venue: where the defendant resides, where the event occurred, where property is located. Why venue rules matter. Filing in the correct venue protects both parties' right to a fair and convenient trial. Improper venue can delay the case, increase costs, or even result in dismissal. What is an improper venue? A venue is improper when the case is filed in a location that doesn't meet legal standards. Defendant doesn't reside there, events didn't occur there, property isn't located there. Example: filing a contract dispute in Texas when all parties and events are in Florida. Consequences of improper venue. A. Dismissal. The court may dismiss the case if the venue is clearly wrong and not correctable. Example: plaintiff chooses a distant venue to inconvenience the defendant. The judge dismisses it. Transfer to proper venue. Courts often transfer the case to the correct venue rather than dismissing it. Done in the interest of justice to avoid wasting time. Example: case filed in the wrong federal district is moved to the proper district automatically. Defendant's right to challenge venue can be challenged early in the case through a motion to dismiss or motion to transfer. If the defendant does not object promptly, the court may consider venue waived. Strategy note: smart defendants raise the venue issue quickly to gain procedural advantage. Prompt: why should the burden fall on the defendant to challenge venue? Practical example exercise scenario: a New York resident sues a California business in Nevada. Question: is this the right venue? If not, what might happen? Answer: venue likely improper, case may be transferred or dismissed. Change of venue reasons. Fair trial concerns prejudicial publicity, convenience of parties, witnesses, motion required. What is a change of venue? Definition: a change of venue moves a case from one proper court location to another to ensure fairness or convenience. Key point: even if the venue is technically correct, a party can still request a change for valid reasons. Fair trial concerns why it matters. A party might not get a fair trial in the original venue due to local bias or conflict. Examples: the defendant is well known or disliked in the community. The plaintiff is highly respected or connected locally. Prompt: should a high-profile defendant be tried in their hometown if the jury already has strong opinions? Prejudicial publicity. What it is. Extensive media coverage can influence potential jurors. Real-world examples: famous criminal trials, viral social media campaigns that sway public perception. Outcome: a motion may be filed to move the trial to a less biased location. Prompt: can the internet make it impossible to find an impartial jury in some places? Convenience of parties or witnesses. Why convenience matters. Courts want to minimize hardship for parties and encourage witness participation. Examples: all key witnesses live far from the original venue. A medical malpractice case is filed in a rural county, but all experts are in a major city. Motion must show that the new venue is significantly more convenient without harming fairness. Why should the court care about how far witnesses have to travel? Motion required. How it happens. A party must file a motion to change venue, stating reasons like inability to get a fair trial, excessive travel burden, media bias, or local prejudice. Timing must usually be done early in the case. Forum shopping. Choosing a favorable court, often controversial courts, may prevent it through doctrine limits. What is forum shopping? Definition: when a plaintiff files a lawsuit in the court or location they believe will give them the most favorable outcome, even if it's not the most logical or convenient forum. Analogy: like picking the judge or jury you think will side with you. If you had the option, wouldn't you want to choose the friendliest court? Why litigants engage in forum shopping, perceived advantages. Local jury bias in favor of plaintiff's speed of docket, favorable laws or procedures. Example: a plaintiff sues a major corporation in a small county court, known for siding with consumers, even if the injury happened elsewhere. Is it wrong to use strategy to get the best chance of winning? Why forum shopping is controversial concerns, undermines fairness and balance in the legal system, can pressure defendants into settling burdens courts with weak or remote cases. Critics say it prioritizes tactics over justice. Supporters argue plaintiffs deserve to choose a forum where they feel the case will be heard fairly. Is it unfair to a defendant to be sued far from where anything actually happened? How courts prevent forum shopping, legal doctrines that limit it. Forum non-convenience. Court can dismiss if there's a more appropriate venue. Transfer of venue. Courts move cases to more proper locations. Personal jurisdiction limits. Prevent cases in courts with no true connection to the parties. Example: a case filed in Texas is transferred to Ohio because all events and witnesses are there. Prompt: should courts have the power to move cases just to make them more fair for everyone involved? Case law example. International Shoe Co. versus Washington established minimum contacts test, changed how personal jurisdiction is assessed. Background of the case facts. International Shoe Co. was a company based in Missouri. It had salesmen working in Washington state, but no office or factory there. Washington wanted the company to pay into its unemployment tax fund. The company claimed Washington didn't have jurisdiction over it. Key legal question: can a state exercise personal jurisdiction over an out-of-state business with limited in-state activity? The Supreme Court's ruling. The court ruled in favor of Washington, holding a state can assert jurisdiction if the defendant has minimum contacts with that state. The contacts must be such that the lawsuit does not offend traditional notions of fair play and substantial justice. The minimum contacts test explained minimum contacts, meaningful ties between the defendant and the forum state. Two key parts: purposeful availment. The defendant must have purposefully engaged with the state. Fairness. It must be reasonable to require the defendant to defend the suit there. Example: a company that regularly sells and ships to California customers can likely be sued in California. Why is it fair to sue a company in a state where it actively does business? Why it matters today before International Shoe. Courts focused more on physical presence. After International Shoe, courts now focus on business relationships and fairness. Applies today, especially relevant in cases involving online businesses and out-of-state companies. Prompt: how might this case affect a company that sells nationwide online? Interactive question. If a resident of Texas sues a company headquartered in Florida for an accident in Georgia, what court has jurisdiction, and where is the venue? Summary: jurisdiction equal authority, venue equals location. Both are essential for legal proceedings. Know how to evaluate and challenge both. Let's apply what you've learned. A California resident sues a New York-based company for a defective product purchased online. Which court has jurisdiction, and where is the proper venue? A criminal trial in a small town has received widespread media attention. Under what conditions could a motion to change venue be successful? A plaintiff files a contract dispute in a state that has no connection to the defendant. Can the defendant challenge jurisdiction? Why or why not? A person is served while visiting another state for a weekend. Does that court automatically have personal jurisdiction over them? A lawsuit is filed in a court with proper jurisdiction, but the venue is inconvenient for all parties. What steps can be taken, and who can request a transfer of venue? Quanda, let's apply what you've learned. Module 3. Filing a lawsuit. What starts a lawsuit? A lawsuit begins with a complaint filed by the plaintiff. A summons notifies the defendant filed in a court with proper jurisdiction and venue. The complaint definition. A legal document that outlines the plaintiff's claims against the defendant. Contents include who the parties are, what happened, what law was violated, what the plaintiff wants. Purpose. Gives the court and defendant notice of the issue. Example. A customer files a complaint alleging a company sold them a defective product. What kind of information do you think should always be included in a complaint? The summons definition. A court-issued document that notifies the defendant they're being sued and must respond. Purpose. Ensures due process. The defendant has a chance to answer the claims. Served by law enforcement, process server, or certified mail. Timeline to respond, usually 20-30 days after service. Why is personal service of the summons important for fairness? Filing in the right court must be filed in a court with subject matter jurisdiction, personal jurisdiction over the defendant. Proper example. A tenant in Atlanta sues their landlord over a security deposit. The complaint is filed in Georgia State Court in the county where the rental property is located. What could happen if a complaint is filed in the wrong court? Complaint, definition and purpose states plaintiff's legal claims, includes facts, damages, and relief requested, must comply with court formatting rules. What is a complaint? Definition. A complaint is a formal legal document filed by the plaintiff that begins a civil lawsuit. It outlines the plaintiff's claims, facts, and demands for legal relief. Filed with the court to officially initiate the case. Why do you think the court requires the case to begin in writing? Purpose of the complaint notifies the court and defendant about the dispute, explains the legal and factual basis of the case, requests relief such as money damages injunction declaratory judgment, helps frame the issues that will be addressed throughout the case. What kind of remedies might someone request in a complaint? Formatting and filing rules must follow the court's rules of civil procedure, including caption numbered paragraphs signed by attorney errors can lead to rejection or need for amendment. Tip: always check local court formatting guidelines. Why is it important that complaints follow a standard format? The official notice informs the defendant they're being sued. List deadlines to respond must accompany the complaint. What is a summons? Definition. A court-issued document that formally notifies the defendant they are being sued. Purpose. Ensures the defendant receives legal notice and has a chance to respond, a core part of due process. Prompt. Why must the court officially notify the person being sued? The role of service. The summons must be delivered to the defendant along with the complaint. Service of process methods. Personal delivery, certified mail publication. Without proper service, the court lacks personal jurisdiction over the defendant. Prompt. What problems could happen if a summons is never delivered to the defendant? Deadlines matter. The defendant must file an answer or response within the timeframe listed. Failure to respond may result in a default judgment. The plaintiff automatically wins. What should someone do if they receive a summons but don't know what it means? Real-world example. A landlord sues a tenant for unpaid rent. Complaint includes rent amount, lease dates, and terms. Summons gives the tenant 30 days to respond. Scenario introduction. Let's walk through how a typical lawsuit begins. A landlord sues a tenant for unpaid rent. This involves both a complaint and a summons. The summons, what the tenant receives delivered with the complaint. The summons notifies the tenant they are being sued, who is suing them, what court to appear in, that they have 30 days to respond. Purpose ensures the tenant has a chance to answer or settle the claim. What could happen if the tenant ignores the summons and doesn't respond? Discussion. Legal rights and responses. File an answer to dispute the claim, negotiate or settle with the landlord. File a counterclaim if the landlord violated lease terms. Key takeaway. A summons is not just a letter, it's a legal deadline. What is service of process? Legally delivering the complaint and summons ensures defendant has notice and opportunity to respond, required before case can proceed. Introduction to service of process definition. The formal delivery of legal documents, usually the complaint and summons, to the defendant. Purpose: to provide notice and a fair opportunity to respond, which is a constitutional right. Why is it important that the defendant be officially notified of the lawsuit? Legal requirements of service of process must be timely, usually shortly after filing the complaint, properly executed, according to local court rules. Who can serve? Sheriff's deputy, licensed process server, sometimes by certified mail when it's valid. The documents are delivered directly to the defendant or left with a responsible adult at the defendant's home, or in some cases, served by publication prompt. What problems might arise if someone other than a qualified server delivers the documents? What happens after service? The server files a proof of service with the court. This lets the court know the defendant was notified, knows their response deadline. The case cannot legally proceed until service is completed. If not served, the court may delay or dismiss the case. Why might a court throw out a case if service was never proven? Real-world example. A tenant is served in person by a process server at their home. The server signs a sworn statement filed with the court confirming delivery. The 30-day clock to respond begins. Key takeaway: without proper service, the defendant might never know they were sued. Methods of service: personal delivery, certified mail service. By publication rules vary by jurisdiction. Personal delivery, most common and preferred method. A process server, sheriff, or other qualified person hand delivers the documents directly to the defendant. Advantages: ensures actual notice, hard to dispute example. A process server hands the defendant the summons at their home. Prompt: why do you think courts prefer personal service when possible? Certified mail documents are sent by certified mail with return receipt. Usually allowed for out-of-state defendants, business entities risk. Defendant might refuse to sign for the mail, making service incomplete. Should a lawsuit be allowed to proceed if the defendant ignores certified mail? Service by publication. Used only as a last resort if the defendant cannot be found after due diligence, is intentionally avoiding service, involves publishing a legal notice in a newspaper or court-approved platform, must be approved by the court first. What are the risks of relying on publication to notify someone of a lawsuit? Jurisdictional rules. Each state or court system has its own rules. Some allow email service in special cases. Timeframes and server qualifications differ. Tip: always consult local rules of civil procedure. Defendant's response: answer: admits, denies allegations, raises defense's motion to dismiss, argues case is invalid on legal grounds, must respond within a set deadline. Why a response matters. After being served with a complaint and summons, the defendant must take action within the deadline or risk default judgment. Responses show the court the defendant is actively participating in the case. The answer: what it is. A legal document where the defendant admits, denies, or claims enough knowledge about each allegation in the complaint. Also includes affirmative defenses, possible counterclaims against the plaintiff. Example: a tenant being sued for unpaid rent might deny the claim and argue the landlord broke the lease first. Prompt: why should a defendant respond to each paragraph of the complaint in an answer? Motion to dismiss: what it is. A legal request to the court to throw out the case before it proceeds, arguing the lawsuit has legal flaws. Common grounds: no legal claim stated, lack of jurisdiction, improper venue, statute of limitations, expired effect. If granted, the case may end early. If denied, the defendant usually must file an answer. Why might a defendant prefer a motion to dismiss over answering right away? Deadlines matter. Most courts require a response within 20-30 days of being served. Missing the deadline can result in a default judgment. The plaintiff wins by default. Tip: file early or request an extension if needed. Motion to dismiss. Lack of subject matter jurisdiction, improper venue, insufficient service of process, failure to state a claim. What is a motion to dismiss? A formal request asking the court to throw out the case before trial, based on the argument that the case is legally flawed, not just factually weak, filed before or instead of an answer. Lack of subject matter jurisdiction, meaning the court doesn't have power to hear this type of case. Example: filing a bankruptcy claim in family court. If the court lacks subject matter jurisdiction, it must dismiss the case. Prompt: why should a court only hear cases it's legally allowed to decide? Improper venue definition. The case was filed in the wrong geographic location. Example: a car accident in Chicago is filed in a rural Illinois county with no connection. The court may dismiss or transfer the case. What makes one location more appropriate than another for a case? Insufficient service of process, meaning the plaintiff failed to properly deliver the summons and complaint, leaving paperwork with a neighbor instead of the actual defendant. Without valid service, the court lacks personal jurisdiction. Why is proper service essential before someone can be required to defend a lawsuit? Failure to state a claim, most common ground for early dismissal. Even if everything in the complaint is true, it doesn't add up to a legal claim, based on Rule 12 in federal court. Example: a customer sues a store for being rude, not illegal, so no valid claim. The complaint must show a plausible legal violation, not just complaints or opinions. Prompt: can someone sue just because they're upset? Why or why not? What if the defendant doesn't respond? Default judgment. Court rules in favor of the plaintiff based on unchallenged facts. Defendant loses right to contest unless reopened. What is a default judgment? If no response is filed, the plaintiff can request a default judgment. The court will then accept the plaintiff's version of the facts as true, award the requested damages or relief. Key feature: the defendant loses automatically without trial. Example: a landlord sues a tenant for $2,000 unpaid rent. The tenant never responds. The court issues a default judgment ordering the tenant to pay $2,000. Can it be reopened? A default judgment can sometimes be set aside if the defendant can prove they weren't properly served, there was a valid reason for not responding, must act quickly, and request relief from the court. Prompt: Do you think courts should always allow a second chance if someone misses the deadline? Example of default: plaintiff sues for unpaid credit card debt. Defendant ignores summons, court enters default judgment for full amount. Scenario setup: a plaintiff files a lawsuit against a defendant. Claim: the defendant owes $5,000 in unpaid credit card debt. The complaint and summons are properly served. Defendant fails to respond. The defendant does not file an answer or motion. No contact with the court. No defense is presented. Deadline passes. Result: the plaintiff files a motion for default judgment. The court's action. The court reviews the complaint and proof of service. Since the defendant didn't respond, the judge assumes the debt is valid, the amount is accurate. The court enters a default judgment for the full amount requested, $5,000. Timeline overview: plaintiff files complaint, summons, issued, service of process completed, defendant responds or defaults, case proceeds, or judgment entered. Summary: complaint and summons start the legal process, proper service is critical. The defendant's timely response shapes the case in action, leads to default judgment. Interactive questions. What happens if a summons is never properly served? Can a defendant raise multiple defenses in one answer? What makes a complaint legally sufficient? Why would someone file a motion to dismiss instead of answering? Is default judgment always final? Module 4: Pretrial Procedure. What is discovery? Legal exchange of information before trial prevents trial by surprise. Parties gather facts, documents, and testimony. Introduction to discovery definition. Discovery is the formal legal process where both parties exchange information before trial. It allows each side to know the evidence, so they can prepare. Goal: prevent trial by surprise and encourage fair settlements. Why might it be unfair if one side hides key evidence until trial? discovery rules and limits must be relevant to the case. Cannot request privileged or harassing information, governed by rules of civil procedure. Court can step in to resolve disputes or limit abusive discovery. Discovery tools: interrogatories, written questions, depositions, sworn out-of-court testimony, document requests, evidence and files. Purpose of discovery tools. These tools allow parties to gather evidence, confirm facts, and prepare their arguments. They help uncover what the other side knows, supports fairness, and may encourage settlement. How might knowing your opponent's evidence affect your legal strategy? Interrogatories definition. Written questions one party sends to the other, which must be answered under oath. Purpose: to gather factual background, timelines, names of witnesses, or other case-relevant information. Example questions. List all persons present at the time of the incident. Describe the injuries you claim resulted from the event. Limits, usually capped. Why do you think interrogatories must be answered truthfully and under oath? Depositions definition. Out of court, sworn verbal testimony from a witness or party recorded by a court reporter who's present. Lawyers from both sides, the deponent and a court reporter. Purpose: to understand the witness's story, to lock in testimony in case it changes later. Example: a doctor in a malpractice case gives sworn testimony about the treatment provided. What advantages does a live deposition give compared to written questions? Requests for documents definition. Formal requests for specific physical or digital evidence. Examples of requested items: medical records, emails and text messages, contracts, photos, receipts, surveillance footage. Purpose: to verify facts and uncover support or contradictions in each side's story. What types of documents might be requested in a breach of contract case? Example scenario: a personal injury lawsuit. Plaintiff sends interrogatories to the defendant. Defendant is deposed by plaintiff's attorney. Requests made for hospital bills and accident photos. Overview of the case. Type of case: personal injury scenario. A plaintiff sues after a car accident claiming serious injuries. The parties now enter discovery to gather facts before trial. Interrogatory sent. Plaintiff's attorney sends the defendant written questions such as: describe how the accident occurred. List any prior injuries or accidents you've had. Were you using a phone at the time of the collision? Get the defendant's version of events and background under oath. Prompt: why might the plaintiff ask about past injuries? Defendant's deposition. The defendant is questioned under oath by the plaintiff's lawyer. Questions cover: driving behavior at the time, speed, distractions, traffic signs, injuries and actions after the crash, why it matters. Locks in the defendant's statements before trial. If their story changes later, the deposition can be used to challenge their credibility. Prompt: what kind of tone and questions would you expect in a deposition? document requests, plaintiff requests. Hospital bills to show the cost of treatment, accident scene photos to prove damage and conditions. Defendant may also request medical history to assess whether injuries were pre-existing. Prompt: how might accident photos help support or weaken each side's story? Why discovery matters, clarifies facts and legal positions, encourages early resolution, allows strategic planning. Clarifies facts and legal positions. Purpose: get to the truth before trial, helps both sides. Confirm what actually happened, identify areas of agreement or dispute, understand each other's legal theories. Example: discovery reveals that both parties agree on the timeline, but disagree on who had the right of way. Prompt: why is it helpful for both sides to know where they disagree before trial? Encourages early resolution. When facts are clear, parties often settle to avoid trial. Saves time, money, and stress. Discovery may show weak evidence for one side, strong support for a claim, opportunities for compromise. Example: medical records prove the injury is less severe than claimed. Parties agree to settle for a lower amount. How might discovery reduce the need for a full-blown trial? Allows strategic planning. With full knowledge of the evidence, attorneys can craft better arguments, prepare stronger witnesses, anticipate the other side's moves, prevents trial by ambush, and builds trust in the system. Prompt: if you were an attorney, how would early access to evidence help your case planning? What is motions practice? Formal requests for court action, resolves disputes, and clarifies rules common during and after discovery. Introduction to motions. A motion is a formal written or oral request asking the court to make a ruling or take action. Think of motions as how lawyers ask the court to step in and make decisions before, during, or after trial. Why might parties need a judge's decision even before trial begins? Timing of motions. Motions can happen at different stages of a case. Before trial, motion to dismiss, motion to compel discovery, motion for summary judgment. During trial, motion to exclude evidence, motion for directed verdict. After trial, motion for new trial, motion to set aside judgment. Prompt: why do you think courts allow motions even after a trial is over? Motions during discovery. Most common time for motions practice. Examples: motion to compel, forces a party to respond to discovery. Motion for protective order, limits discovery to protect a party. Motion for sanctions, punishes misuse of the discovery process. What should happen if one side refuses to share critical evidence? Key pretrial motions. Motion to compel enforces discovery compliance, motion for summary judgment, ends case without trial if no facts are disputed. What are pretrial motions? Filed before trial, usually after discovery. ask the court to make a decision on a legal issue, or enforce a rule, can shape the trial or end the case entirely. Motion to compel definition, a request for the court to force a party to comply with discovery rules. When it's used, one side refuses to turn over evidence, interrogatories or document requests are ignored, depositions are dodged or incomplete. Court can respond by ordering compliance, awarding attorneys fees, imposing sanctions for non-compliance. Example: defendant refuses to produce security footage in a slip and fall case, plaintiff files a motion to compel. What might happen if one party ignores discovery deadlines repeatedly? Motion for summary judgment definition, a request to end the case without trial because no material facts are in dispute. Only legal questions remain. When it's used, after discovery, when the moving party believes the facts are clear and undisputed, the law is on their side. Effect: if granted, case is resolved early. If denied, case proceeds to trial. Example: plaintiff sues for breach of contract, but discovery proves no contract existed. Defendant files for summary judgment. Why should a court skip a trial if both sides agree on the facts? Motion example: defendant refuses to provide emails, plaintiff files motion to compel court orders compliance. Plaintiff responds: plaintiff files a motion to compel, asking the court to order the defendant to provide the emails, possibly impose sanctions or fees for the delay. Why it's important: these emails might prove discriminatory behavior or a hostile work environment. Without them, the plaintiff cannot fully present their case. What risks does a defendant take by refusing to hand over potentially important evidence? Court's action. The judge reviews the discovery request, the defendant's refusal, whether the emails are relevant and discoverable. Court orders. Defendant must turn over the emails, may also warn or penalize the defendant if refusal was unreasonable. Legal impact. Enforces fairness in the process, prevents parties from hiding evidence, reinforces importance of court rules. Pre-trial conferences, court-led meeting with both parties, establish trial timeline, and discuss settlement, set final deadlines for evidence and motions. What is a pre-trial conference? A court-supervised meeting between the judge and both parties, typically held after discovery and before trial. Purpose: streamline the case and avoid surprises at trial. Setting final deadlines. Court will lock in deadlines for filing pretrial motions, submitting exhibits and witness lists. Jury instructions. Effect: ensures both sides are fully prepared and no one can spring new evidence at the last minute. Example: the court sets a final deadline for submitting expert reports 2 weeks before trial. Encouraging settlement. Judges often use pretrial conferences to gauge how far apart the parties are, suggest mediation or negotiation, push toward resolution without trial prompt. Why might parties be more willing to settle during this phase of the case? Benefits of pretrial conferences: promotes efficiency, narrows issues, encourages dispute resolution. Promotes efficiency, schedules are confirmed, deadlines are enforced, avoids last-minute delays or confusion, encourages organization, less time is wasted on procedural issues. Example, a judge ensures all motions are filed 2 weeks before trial, reducing courtroom chaos. How does locking in dates early help both sides stay accountable? Narrows the issues parties, identify what's actually in dispute, removes unnecessary claims, evidence, or witnesses, focuses the trial on key legal questions. Example, parties agree on liability, but disagree only on the amount of damages, so trial focuses just on compensation. Why is it helpful to limit the trial to the most important issues? Encourages dispute resolution. Judges often ask, can this case settle? Would mediation help? If both sides are close, the judge may facilitate a deal, saving everyone time and money. Example, after reviewing evidence, both parties agree to a settlement instead of going to trial. Why might parties be more open to settling during a pretrial conference? Settlement and mediation. Settlement, agreement before trial. Mediation, neutral third-party guides negotiation focused on saving time and cost. Introduction. Alternatives to trial. Most civil cases don't go to trial. Instead, parties often resolve disputes through settlement or mediation. These methods are faster, cheaper, and more flexible. What is settlement? Definition: a mutual agreement to resolve the case before trial. Can happen before a lawsuit is filed, during discovery, even right before trial may involve. Payment of money. Agreement to stop certain actions. Confidentiality. Terms. Example, a company agrees to pay $10,000 in a discrimination case to avoid trial and negative publicity. Why might both parties prefer a private settlement over a public trial? What is mediation? Definition: a structured negotiation guided by a neutral third party. The mediator does not decide the case, facilitates conversation between the parties, helps find common ground, often used by courts before trial to encourage compromise. In a landlord-tenant dispute, a mediator helps both sides agree to a payment plan instead of eviction. Prompt: what qualities make a good mediator? Why cases settle. Uncertainty of trial outcomes, expense, and time of litigation. Parties retain control over terms. Uncertainty of trial outcomes. Trials are unpredictable. Jury decisions can be surprising. Judges may rule unexpectedly on evidence or law. Even with strong evidence, outcome is never guaranteed. Example, a plaintiff may win less than expected or lose completely, even with good facts. How would uncertainty affect your decision to go to trial? expense and time of litigation. Trials involve court fees, expert witnesses, attorney fees, time away from work or life. Cases can take months or even years to reach trial. Example, a simple injury case may cost $30,000 plus in legal fees if it goes to trial. Settling early might resolve it for far less. Prompt: how might cost influence both parties' willingness to settle? Control over outcome. Settlement gives parties power to decide the terms, keep matters private, craft creative or flexible solutions. Example, instead of money, a settlement might include job reinstatement, a written apology, or future non-disparagement. Prompt: why might having control over the result be better than letting a judge or jury decide? Mediation in practice: confidential, voluntary, non-binding, often led by a retired judge or attorney, can happen at any point pre-trial. What is mediation? Mediation is a structured negotiation process between parties. A neutral third party helps guide the discussion, but does not decide the outcome. It's designed to be cooperative, not confrontational. Who leads mediation? Often a retired judge, experienced attorney, or certified mediator. They are trained to keep things neutral and respectful, help both parties understand the risks and benefits, suggest possible solutions. Example, a former judge mediates a complex employment dispute, helping the parties reach a mutual agreement in one afternoon. When does it happen? Mediation can occur before a lawsuit is filed, during discovery, right before trial. Some courts require mediation before setting a trial date. Why might parties be more open to settling once they've seen all the evidence in discovery? Summary discovery builds the case, motions resolve legal questions, early pretrial conferences and mediation help streamline or resolve disputes. Discussion questions. What is the purpose of a deposition? Why would a party file a motion to compel? When might summary judgment be granted? What happens during a pretrial conference? How can mediation benefit both parties? Module 5, Trial and Judgment. What is a trial? A formal process for resolving disputes. Involves presentation of evidence, witnesses, and legal arguments. Culminates in a decision by a judge or jury. Jury versus bench trial, jury trial. Decision made by a group of peers, bench trial. Judge decides both facts and law, often determined by case type or party request. Jury trial definition. A trial where a group of 6-12 jurors determine the outcome based on evidence. Pros. Community perspective. Right to jury in many civil cases. Cons. Can be unpredictable, more time-consuming and expensive. Example. A personal injury case goes to jury trial. Jurors decide if the defendant was negligent and how much the plaintiff should be compensated. Prompt. What kinds of cases might benefit from the emotion and perspective of a jury? Bench trial definition. A trial without a jury, the judge makes all decisions. Pros. Faster and more efficient, useful when facts are complex and legal reasoning is critical. Cons. No peer input, one person controls the entire outcome. Example. A contract dispute goes to bench trial where a judge interprets the agreement and applies the law. Prompt. Why might a lawyer choose a bench trial in a highly technical case? How is the type chosen? By law. Some cases require or exclude jury trials. By party request. Either side can typically request a jury trial. If no request is made, it defaults to a bench trial. Pros and cons of each jury trial. Bench trial. Community perspective. Faster resolution. May be unpredictable. Judge focuses on law, constitutional right, no jury persuasion needed. Presentation of evidence. Direct evidence. Documents, testimony, videos, cross-examination. Challenges credibility, governed by strict rules of admissibility. Direct evidence definition. Evidence that directly proves a fact without inference. Types. Documents, testimony, videos, photos. Example. A video shows the defendant running a red light, direct proof of fault. Why is it important for evidence to be authentic and reliable? Cross-examination definition. The opposing party questions a witness after direct examination. Purpose. Challenge the truth or accuracy of statements, test the witness's credibility or bias. Example. A defense attorney cross-examines a witness who previously gave a conflicting statement under oath. Prompt. How does cross-examination help uncover the full truth? Rules of admissibility. Courts follow strict rules about what evidence can be shown. Relevance. Must relate directly to the case. Reliability. Must be trustworthy. Prejudice versus probative value. Evidence can't unfairly sway the jury. Judges act as gatekeepers of evidence. What's the danger of allowing unreliable evidence into a trial? Witness testimony, lay versus expert. Witnesses must testify under oath, may include fact witnesses, medical professionals, etc. testifying under oath, every witness swears to tell the truth before speaking. Purpose: to protect the integrity of the legal process. Violations can lead to criminal charges for perjury. Example: a witness lies about seeing the accident, later security footage proves otherwise. Why is honesty under oath critical in a civil trial? Common witness types in civil cases: fact witnesses, neighbors, co-workers, bystanders, medical professionals, doctors, nurses, therapists, technical experts, engineers, economists, IT specialists. Each one adds perspective to help the judge or jury understand key facts. Prompt: if you were injured in a lawsuit, what kind of witnesses might help prove your case? Burden of proof in civil cases: plaintiff must prove their case. Preponderance of evidence equals, more likely than not, lower standard than criminal cases. What is the burden of proof? The burden of proof determines who must prove what in court. In civil cases, the plaintiff has the burden to prove their claims. Why do you think the person making the accusation must carry the burden of proof? Applying the standard 51% certainty is enough. Jury or judge assesses credibility and weight of evidence. Burden remains on plaintiff throughout. Verdict: jury deliberates privately after closing arguments, must reach a consensus. In bench trials, judge delivers verdict directly. Judgment: formal, written decision by the court may award damages, order relief, or the case becomes legally binding. Post-trial motions: motion for a new trial, motion to alter, amend judgment. Rare, but sometimes successful. Appeals: quick overview. Not a retrial focuses on legal errors made during trial. Appellate court can affirm, reverse, or remand the decision. Appeals example: a party believes evidence was improperly excluded, files a notice of appeal. Appellate court reviews record, not new evidence. Summary trials involve structured presentation of evidence. Burden of proof is lower than in criminal cases. Judgment finalizes the decision. Appeals offer limited review. Discussion questions. When would a party choose a bench trial over a jury trial? What types of evidence are strongest in civil cases? How does preponderance of the evidence affect strategy? Why might a judgment be appealed? Can a verdict be overturned? Module 6, Reviewing Case Scenarios. Case scenario: Smith versus Jones. Facts. Smith sues Jones after a car accident in Georgia. Jones lives in Alabama. Issue: can Smith sue in Georgia? Concepts: personal jurisdiction. Venue discussion prompt. What would the court consider? Hypothetical 1, jurisdiction scenario. A New York company sues a Florida resident in California. Does California have personal jurisdiction over the defendant? Key concept: minimum contacts. Yes, no. Hypothetical 2, pleading scenario. Plaintiff files a vague complaint. Question: what motion can the defendant file? A, motion for summary judgment. B, motion to dismiss. For failure to state a claim, C, motion in limine. D, motion to strike jury demand. Hypothetical 3, motion scenario. Discovery reveals no real factual dispute. Question: what motion should be filed? Correct answer: motion for summary judgment. Use a checklist for Rule 56 standard. Recap: key takeaways. Jurisdiction must meet due process and state law. Complaints must allege facts that state a legal claim. Summary judgment can resolve cases before trial. Civil procedure is a strategic and legal process. Q1. Which motion challenges the legal sufficiency of the complaint? A, motion to dismiss. B, motion for summary judgment. C, motion to compel. D, motion to remand. Q2. What phase allows parties to obtain evidence from each other? A, pleadings. B, discovery. C, motions. D, trial. Q3. A party files a motion claiming there's no factual dispute. What is it? A. Motion to dismiss. B. Motion in limine. C. Motion for summary judgment. D. Motion for new trial. Q4. Where is venue proper? A. Only where defendant resides. B. Only where plaintiff resides. C. Where defendant resides or where events occur. D. Any federal district. Q5. Which court has subject matter jurisdiction over federal claims? A. State court. B. Federal court. C. Probate court. Tax court. Q6. What starts a civil lawsuit? A. Motion to dismiss. B. Complaint. C. Answer. D. Subpoena. Q7. A party is served in another state. What rule applies? A. Personal jurisdiction. B. Long-arm statute. C. Subject matter jurisdiction. D. Removal. Q8. What's the purpose of pleadings? A. Punish wrongdoers. B. Establish criminal liability. C. Frame the issues in a lawsuit. D. Collect evidence. Q9. What can be used to avoid trial when facts are undisputed? A. Jury trial. B. Discovery. C. Summary judgment. D. Interrogatories. Q10. Who decides issues of fact in a jury trial? A. Judge. B. Jury. C. Plaintiff. D. Clerk. Final thoughts. Great work completing the module. Review any questions missed in the quiz. Civil procedure is the backbone of litigation. Certificate info. Upon passing the quiz, you'll receive a certificate of completion. Congratulations on completing the Civil Procedure series.